Demanding to be declared innocent in the Ukraine scandal, President Trump is slamming House Speaker Nancy Pelosi's decision to hang on to the articles of impeachment while negotiations continue over the upcoming trial in the Senate. The president tweeted, "Actually, they have zero proof of anything. They will never even show up. They want out. I want an immediate trial." Mr. Trump's personal attorney, Rudy Giuliani, told young conservatives at the Turning Point USA summit, Democrats are out for blood.
They want to put Barr in prison, and they want to execute me. Good luck. I just get angrier and I go after you more.
The president's daughter, Ivanka, concedes her father is upset.
Angry at the waste of time, angry at the collateral damage, angry, but it's still energizing, and it focuses you on, really, and draws into relief the stark contrast in priorities.
That will be in order.
But Pelosi appears to be getting in some digs of her own, inviting the president to deliver the State of the Union around the time of Mr. Trump's trial, writing in a letter, "In the spirit of respecting our Constitution, I invite you to deliver your State of the Union address before a joint session of Congress on Tuesday, February 4th, 2020.
What's good, people? Dr. John Podcast is back again. Donald Trump has already been impeached twice by the House, more than any other president in American history, and both times the Senate fell short of conviction. That track record has led many to conclude impeachment is ineffective against him. But the documented record of his two previous impeachments now forms the foundation of a growing third impeachment movement, fundamentally different from anything that came before. For a while, that cynicism felt justified. But something has shifted. Something significant and structural has changed in the legal and political landscape around this president. And the people who study these things, the constitutional lawyers, the federal judges, the impeachment advocates who have been tracking his second term closely, they are now saying something they were not saying before. They are saying that the walls are closing in from a direction Trump did not fully account for.
But an expert witness for the Democrats during the inquiry is warning Pelosi should get on with it, writing in an op-ed, "If the House does not communicate its impeachment to the Senate, it hasn't actually impeached the president." Democrats aren't buying that.
Absolutely. After the vote that we took on the floor and, the majority of Congress voted to impeach the president, he has absolutely been impeached.
As Christmas is approaching, the president is all but saying bah humbug to the religious publication Christianity Today, which is calling for Mr. Trump's removal over his actions in Ukraine. The president blasted the website as a far-left magazine, but that's not true, according to its editor.
It's factually inaccurate that we're far left. We're pretty centrist. We rarely comment on politics unless we feel it rises to the level of some national or concern that is really important, and that this would be a case.
Mr. Trump tweeted, "The fact is, no president has ever done what I have done for evangelicals or religion itself." But while the president is popular among Christian conservatives, he rarely attends church and has at times puzzled his own faithful, whether by signing Bibles or misquoting passages from the scripture.
2 Corinthians, right? 2 Corinthians 3:17. That's the whole ballgame.
The courts are no longer buying the immunity arguments that once gave him a kind of legal force field. A growing block of federal judges is actively vacating the rulings that have been protecting him from prosecution. Impeachment campaigns backed by more than 250,000 supporters are filing detailed legal arguments about his second-term conduct. Members of Congress, who were once reluctant to engage with the impeachment conversation, are now using words like imminently when calling for proceedings to begin. The pattern of behavior that keeps repeating itself and escalating with every cycle has transformed the conversation from abstract to immediate. This is not just noise. This is a structural shift. And today we are breaking down exactly what changed, why it matters, and what a third impeachment would actually look like if it moves forward. Stay with me because this story has more layers than most people realize.
Now, the president is tweeting about House Speaker Nancy Pelosi. We can put this up on screen, insisting she should be impeached for demanding a fair trial in the Senate. And even with all of that friction tonight, the president has accepted Pelosi's invitation to deliver that State of the Union in early February. But that could be messy if the president's impeachment trial is still underway. At the moment, House Democrats are planning for a trial in early January, despite this current delay. And next, the president is off to Mar-a-Lago. He does that later on this evening for his winter vacation. Will he be celebrating the holidays and making one resolution for the new year: exoneration. Wolf.
Jim Acosta at the White House, thank you. Let's get some more on all of this. Democratic Representative Jim Himes of Connecticut is joining us. He's a key member of the Intelligence Committee. Congressman, thanks so much for joining us. And as you saw, the president says Nancy Pelosi is looking for a quid pro quo, his words, with the Senate. What's your reaction?
Well, it's nonsense, Wolf. The president is raging because for the very first time in his life, he has been held accountable for his actions. Actions that were plain for everyone to see, that he held up military aid, that he held up a White House meeting, that he just wanted a favor. And that favor, of course, was an announced investigation into his political opponent.
To understand why this moment is different, you need to understand what has been holding back the accountability machinery up until now, and what is starting to give way. The single biggest legal shield the president has relied on across both terms is a broad theory of presidential immunity. The argument stripped to its core is that a sitting president, and potentially even a former president acting in his official capacity, cannot be prosecuted or held criminally accountable for actions taken as part of the duties of the office. That argument has been litigated repeatedly. It has been the foundation of his legal team's strategy in multiple courts across multiple cases. For a while, in the lower courts, in the Supreme Court's immunity ruling, and in the political calculations of Senate Republicans, that shield held. Not perfectly, not without challenge.
And so for the first time in his life, this president is being held accountable. He, of course, is being completely defended by those complicit in his presidency, my Republican colleagues and his family, who are trying to flip this back around to be a problem with the Democrats. Remember, this impeachment was not about the Democrats. It was about the president's behavior, and it also didn't waste any time at all. I'm a little exhausted at the end of this week because while the impeachment occurred, we also passed a massive trade agreement. We passed a budget to prevent the government from being shut down. We passed a bill to reduce pharmaceutical and drug prices for the American people. So what you're seeing, Wolf, here is a president who, for the very first time in his life, is being held accountable, and boy, he does not like that.
As you know, Professor Noah Feldman, a Harvard Law School constitutional scholar who was a key witness, by the way, for the Democrats, says President Trump isn't actually impeached until this moves over to the Senate. The articles of impeachment are actually sent over from the House to the Senate. How do you respond to his analysis?
But enough to slow down the accountability process and give the president room to operate. That is what is now crumbling. What has been described as a legal body blow for the president has emerged from a string of court setbacks in which federal judges are no longer accepting the broad immunity arguments his team has been advancing. The single most significant moment in that sequence came when a block of federal appellate judges voted to vacate a lower court ruling that had been shielding the president from prosecution. 29 appellate judges. That is not a minor procedural development. That is a major signal from the federal judiciary that the immunity theory is not holding the way his legal team needs it to hold. A former acting solicitor general, one of the most respected legal voices in the country on these questions, called it a terrible sign for the president's efforts to stay beyond the reach of criminal and impeachment-related investigations. A terrible sign from someone who argues before the Supreme Court for a living. That is not hyperbole. That is a careful, calibrated legal assessment from someone who knows exactly what that kind of ruling means for what comes next. The Venezuela dimension adds a critical layer to this conversation. The president authorized military action in a foreign country, bombing the capital, seizing oil assets, and taking the country's leader and his wife into custody. All of this happened without congressional authorization, without a formal declaration of war, without the kind of legislative sign-off that the Constitution requires when a president commits the country to military action in another sovereign nation. The reaction inside Congress was immediate and sharp. A representative urged the Democratic caucus to immediately consider impeachment proceedings. A state senator called the invasion illegal and described it as yet another impeachable offense, saying the president is acting like he can just run another country as if it is a subsidiary of the United States. Here's what makes the Venezuela situation more legally potent than it might look on the surface. It is not just the action itself, it is the pattern it fits into. The president did not start his second term by bombing foreign countries on day one. He built to it. He tested limits progressively. He defied court orders on foreign aid. He refused to comply with rulings on federal hiring freezes. He ignored orders requiring officials to testify about mass federal firings. Each act of defiance a little bolder than the last. twist. The impeachment lawyers who have been tracking all of this are now arguing that the pattern itself, the accumulation of defiance, the escalating disregard for both the judiciary and the legislature is the core of the impeachment case. Not just Venezuela, not just the court orders, the whole trajectory. With hundreds of thousands of people signed onto the impeachment campaign already and a crumbling immunity shield in the courts, the political calculus around a third impeachment is starting to look different than it did 6 months ago. A nonpartisan group launched what they are calling an Impeach the President Again campaign. Their legal director laid out the argument in terms that are worth taking seriously, regardless of where you sit politically. They argue that the president has usurped the powers of the legislature and now tramples on the authority of the judiciary, and that Congress must adhere to its own obligations to carry out an impeachment investigation. They are pointing specifically to his refusal to release billions in foreign aid despite multiple court rulings ordering it, his refusal to comply with orders blocking a freeze on all federal assistance, his defiance of a court order requiring a senior official to testify in person about mass federal firings. These are not policy disagreements. These are instances where a court issued a legally binding order and the executive branch refused to comply. When a president refuses to comply with court orders, not as a one-time aberration, but as a repeated deliberate pattern, the constitutional system has a specific remedy for that. It is called impeachment. The lawyers who are now making that argument are not doing it from the fringes. They are making it with detailed legal filings, specific precedents, and the backing of a growing number of people inside and outside Congress who are no longer willing to treat court defiance as just controversial policy. What is particularly notable about this campaign is not just the hundreds of thousands of signatures. It is the specific legal architecture of the argument. They are not arguing that the president is bad or that his policies are wrong. They are pointing to specific court orders, specific refusals to comply, specific instances of constitutional violation. That kind of documented court-grounded argument is very different from a political campaign calling for impeachment because of general dissatisfaction with the president's agenda. This is a legal case being built in public in real time with receipts. The first two impeachments were treated as isolated events, specific incidents that got adjudicated and then closed. What is being built now is something different. It is a cumulative case, a record that keeps growing with every court order defied, every unauthorized military action, every congressional demand brushed aside. Cumulative cases have a different weight than single incident cases. They are harder to dismiss as aberrations, harder to frame as misunderstanding, and harder for the Senate Republicans who protected the president twice before to wave away with the same arguments they used successfully in previous years. To understand why this moment is different from the first two impeachments, you need to understand what those first two impeachments actually established, why they failed, and how the legal and political landscape has shifted in ways that changed the equation for a potential third. Start with the first impeachment. The president was impeached by the House for pressuring a foreign country's leader to investigate a political rival in exchange for military aid and a White House visit. The core allegation was that he used the power of the presidency to extract a personal political benefit from a foreign government, essentially weaponizing foreign policy for his own electoral advantage. The House voted to impeach, the Senate acquitted, and the acquittal happened not because Republican senators believed he was innocent. Several of them said publicly that his conduct was wrong and inappropriate. It happened because they did not believe it rose to the level of a removable offense, or because they calculated that voting to convict a president of their own party was a political risk they were not willing to take. The legal and political shield held barely, but it held. Then came the second impeachment. The president was impeached for inciting the attack on the Capitol. The charge was incitement of insurrection, that his words and actions before that day directly caused a mob to storm Congress in an attempt to prevent the certification of a legitimate election. This one was even more politically charged than the first. Again, the Senate acquitted, even though 7 Republican senators voted to convict. The most bipartisan impeachment vote in American history. It was still not enough to reach 67. In the defense, the president's team leaned heavily on the immunity argument, the idea that his speech was protected as an official act of the presidency, and that impeaching and convicting him for it would set a dangerous precedent for criminalizing political speech. That argument was contested by impeachment managers, but it was effective enough in the court of Senate Republican opinion to hold the line on conviction. The president walked again. The lesson his team drew from both acquittals was consistent. Build the immunity wall higher. Keep the Senate in line. The accountability process cannot touch him. But here's what changed. The same immunity theory that protected the president in the impeachment trials, the broad claim that presidential actions in office are shielded from accountability, has now been significantly weakened in the actual federal courts. Not by political opponents, not by Democrats, but by federal judges, including appellate judges appointed by Republican presidents who are applying legal standards rather than political calculations. When 29 appellate judges collectively vote to vacate a ruling that was shielding the president from prosecution, they are not making a partisan statement. They are making a legal one. They are saying that the immunity theory does not hold up to scrutiny under the law. When the most respected constitutional lawyers in the country say that ruling is a terrible sign for the president's position, they are telling you something important about where the legal ceiling of protection actually sits now versus where it sat a year ago. The shield is smaller, the exposure is larger, every new act of defiance, every court order ignored, every unauthorized military action, every congressional demand brushed aside is now landing in a legal environment where the immunity cushion that once absorbed those blows is thinner than it used to be. The Venezuela operation is the freshest and most vivid example of the kind of executive overreach that the impeachment lawyers are pointing to. What the president did was not a covert intelligence operation or a limited strike. It was a full military action, bombing a capital city, seizing a sovereign nation's oil assets, and physically taking a sitting head of state into American custody without a declaration of war from Congress, without an authorization for the use of military force, without the kind of explicit legislative sign-off that the Constitution requires for exactly this kind of action. The War Powers Resolution, which has been a contested but legally significant framework for limiting presidential military action since the 1970s, requires the president to notify Congress within 48 hours of committing troops to hostilities and to withdraw those troops within 60 days unless Congress authorizes the action. The president's Venezuela operation did not go through that process in any meaningful way. The constitutional lawyers making the impeachment argument are pointing to that gap between what the Constitution requires and what actually happened as the clearest and most recent example of a president acting as though the legislative branch simply does not exist when it is inconvenient. A representative did not use cautious language when she called on the Democratic caucus to imminently consider impeachment proceedings. She used the word imminently deliberately because from where she and others in Congress are sitting, the Venezuela action is not a close call. It is a textbook example of the kind of unilateral executive overreach that impeachment exists specifically to address. Here is the through line that the impeachment lawyers keep returning to. The first impeachment was about a specific corrupt transaction, foreign country, military aid, a political favor. The second was about a specific inciting event, a speech, a mob. Both of them were tied to discrete moments that could be isolated, argued around, and ultimately survived the Senate's political calculation that conviction was too costly. The third impeachment case that is being built now is about something different. It is about a sustained escalating pattern of behavior in which the president has repeatedly and deliberately chosen to operate outside the constitutional limits on his power, defying courts, bypassing Congress, seizing resources, bombing countries, and has done so not as isolated lapses in judgment, but as a coherent governing philosophy. The argument is that when a president treats the separation of powers as optional and the rule of law as something that applies to other people but not to him, that is not a policy disagreement. That is a constitutional crisis. The remedy the founders built into the system for a constitutional crisis of that scale is impeachment, not as punishment, but as a structural correction. What does it actually mean for the impeachment push, for the president's legal exposure, and for the constitutional questions that are going to define American politics for years, regardless of how this specific moment resolves? The first thing to understand is what the crumbling immunity shield actually changes. Up until recently, the broad immunity theory gave the president a kind of legal buffer that made accountability, whether through the courts or through Congress, extremely difficult in practice. Even if there was political will to hold him accountable, his legal team could point to the immunity arguments and create enough uncertainty about the legal foundations to slow things down, muddy the water, and make the calculus of impeachment or prosecution feel too risky or too uncertain for the people who would have to carry it out. That buffer is now measurably smaller. When 29 appellate judges vacate a ruling that was protecting him from prosecution, that is not just a setback in one case. It is a signal to every court, every prosecutor, every congressional investigator who is watching that the immunity wall is not as solid as it looked. Signals like that have cascading effects. They change what investigators think is worth pursuing. They change what legal scholars think is defensible. They change what members of Congress think they can justify to their constituents. The legal landscape around the president in his second term is materially different from what it was in his first. The immunity shield collapsing is the single biggest reason why. The second thing to understand is what makes the Venezuela case so legally significant as a potential impeachment ground compared to the first two. The first impeachment required proven corrupt intent that the president was using military aid as a personal bargaining chip for political benefit. That is a fact-intensive argument that is easy to dispute and reframe. The second impeachment required proven incitement, that his specific words caused specific violent acts. Also a difficult standard to meet in the absence of a direct verbal order. The Venezuela case is structurally simpler from a constitutional standpoint. Either the president has the authority to unilaterally conduct full-scale military operations against a sovereign nation without congressional authorization, or he does not. That is not primarily a question of intent. It is a question of constitutional structure. The constitutional structure on this is actually pretty clear. The founders gave Congress the power to declare war specifically because they did not want the executive to be able to take the country into armed conflict unilaterally. The president's Venezuela operation put the country into armed conflict with another nation without going through that process. That is a cleaner and more structurally obvious constitutional violation than either of the first two impeachments, which is precisely why legal experts are saying the third push is more serious than the earlier ones, even if the political path to conviction remains very difficult. The third thing, and this is the one that has the longest implications, is what this moment means for the balance of power between the branches of government going forward. Every time a president defies a court order without consequence, the authority of the courts is weakened a little. Every time a president wages war without congressional authorization and faces no accountability for it, the war-making power of Congress is weakened a little. Every time an impeachment process fails to convict because the political cost of conviction is too high, the deterrent value of impeachment as a check on executive overreach is weakened a little. The president's two acquittals did not just let him walk free. They established a precedent that even clearly impeachable conduct in the judgment of many constitutional scholars does not necessarily result in removal if the political will in the Senate is not there. That precedent has a cost, not just for how this president operates, but for how every future president calculates the risk of crossing constitutional lines. If the lesson of these years is that you can defy courts, bypass Congress, wage unauthorized wars, and still survive the accountability process, then the constitutional limits on presidential power have been meaningfully eroded. Restoring them requires not just legal arguments in court, but political will in Congress. Will that political will materialize for a third impeachment? The honest answer is probably not. The math in the Senate has not changed enough to make conviction likely, even if the House votes to impeach. Republicans would still need to supply a significant portion of the 67 votes required. Most of them, despite the quiet rebellion on specific votes, are not there yet on something as dramatic as removing their own president. But here's the thing about that Senate math. It is not static. Approval ratings in the mid-30s heading into midterms change political calculations. Republicans with nothing left to lose get bolder as elections approach. The legal landscape is continuing to shift in ways that make the president's exposure larger with every passing month. The campaign is real. The legal arguments are substantive. The court developments are genuinely significant. The Venezuela operation has given impeachment advocates the clearest constitutional hook they have had since the second impeachment, arguably clearer. But the political path remains narrow. The House would need to vote to impeach, which requires Democratic unity and at least a handful of Republicans willing to cross the line. The Senate would need to convict, which requires a supermajority that does not currently exist. What the current moment does create is a framework, a building case file, a documented record of conduct that future investigators, future prosecutors, and future Congresses will be able to point to and build on. The first two impeachments established the pattern. The legal arguments being made now are extending that pattern into second-term conduct. The crumbling immunity shield means that even if impeachment does not succeed politically in the short term, the legal exposure that has historically followed this president after leaving office is larger and more concrete than it has ever been. The walls are not closing all the way, not yet, but they are moving. The direction they are moving toward accountability rather than away from it is something the president's team is watching very carefully and is very clearly worried about. The legal filings are multiplying. The appellate judges are not backing down. The impeachment advocates are not running out of new material to add to the case file. The political environment with approval in the mid-30s, a fractured Senate coalition, and midterm elections that are starting to look genuinely dangerous for the party in power is not generating the kind of solidarity that protected the president in both prior Senate trials. None of that guarantees a third impeachment succeeds where the first two failed, but it does mean the conversation is no longer hypothetical. It is operational. The people closest to it on both sides know it. The first impeachment was about Ukraine. The second was about January 6th. The third, if it comes, will be about something larger than any single incident. It will be about a pattern of conduct that has repeatedly and deliberately crossed constitutional lines. It will be about a president who has treated the separation of powers as optional and the rule of law as something that applies to other people but not to him. It will be about whether the constitutional system has the capacity to correct a sustained pattern of executive overreach when the political will to do so is uncertain. The founders built impeachment into the Constitution because they understood that there might come a time when a president would test the limits of the system in ways that ordinary politics could not address. They understood that the capacity to remove a president who had become a threat to the constitutional order was essential to the survival of that order. They did not make it easy. They set the bar high precisely because they did not want impeachment to be used for ordinary political disagreements. But they did make it available for exactly the kind of sustained pattern of constitutional violation that impeachment advocates are now documenting. The documented record of court defiance is growing. The documented record of unauthorized military action is growing. The documented record of congressional disregard is growing. The immunity shield that once protected the president from accountability is crumbling. The legal arguments for impeachment are more detailed and more grounded in specific constitutional violations than they have ever been. The number of people calling for impeachment is larger and more diverse than it has ever been. And the political environment is more volatile than it has ever been. None of this guarantees that a third impeachment will succeed. The Senate math remains daunting. The political cost of conviction remains high. The president's ability to rally his base remains significant. But the conversation has shifted. It is no longer a fringe idea. It is no longer dismissed as theater. It is a serious constitutional question being debated by serious people with serious arguments. And however it resolves, the fact that the conversation has reached this point is itself significant. It tells you something about where the country is and where the constitutional system is being tested. The next chapter of this legal and constitutional story will be written by what happens in the courts over the coming months. Whatever they decide will echo through American political life for a very long time. The immunity question is being litigated in real time. The impeachment question is being debated in real time. The balance of power between the branches of government is being tested in real time. And the outcome of these tests will shape American governance for generations to come. The president has survived 2 impeachments. The possibility of a third is now real in a way it has not been before. The legal shield is weaker. The documented record is stronger. The political environment is more volatile. The constitutional arguments are clearer. Whether all of this translates into actual accountability remains to be seen. But the fact that it is being seriously discussed by serious people in serious institutions is a development that deserves attention. The walls are closing in. Not all the way, not yet, but they are moving. And the direction they are moving is toward accountability. That is the story of this moment. That is what has changed. And that is why the conversation about a third impeachment is more serious than the conversations about the first 2 ever were.